हॅलो गाईज, वेलकम टू इझी लिगल लॉ. आपण पाहत आहोत रिअल इस्टेट लॉज. त्यामध्ये पाहणार आहोत आपण महाराष्ट्र रेंट कंट्रोल ऍक्ट. द महाराष्ट्र रेंट कंट्रोल ऍक्ट 1999 balances the protection of tenants from exorbitant rents with the landlord's right to maintain the property and receive a fair return. Section 8 to 14 and 25 to 27 form the core of these daily operational rules. Section 8 to 11 Standard rent. Standard rent is the legally capped rent for a property. It prevents landlords from arbitrary spiking prices. Section 8 Fixation by court. If there is a dispute, the court can fix the standard rent based on the rent at which premises were let on October 1, 1987. If not let, then the rent at which they were first let after that date. Section 11 Permitted increases. To ensure the rent doesn't stay frozen forever, a major flaw of the old 1947 Act, landlords are allowed 4% annual increase, a standard yearly hike, 15% increase for improvements if the landlord adds amenities or makes structural alterations with tenant consent. Special or heavy repairs. If landlord carries out heavy repairs, they can increase the rent further as permitted by the Act. Excess rent is illegal. Section 10. Charging anything above the standard rent plus permitted increases is punishable offense. Section 14. Repairs, duties and rights. One of the most common friction point in a tenancy is who pays for the leaking roof or broken pipes. Landlord's mandatory duty. Every landlord is bound to keep the premises in good and tenable repair regardless of any contract unless the tenant specifically agrees over otherwise. The 15-day notice rule. If the landlord neglects repair, the tenant can serve a 15-day notice. Tenants repair to self-repair. Tenants right to self-repair. If the landlord still doesn't act, the tenant can carry out the repairs themselves. Deduction from rent. The tenant can deduct the cost of these repairs from the rent. Limit. The amount deducted cannot exceed 1/4, 25% of the annual rent payable for that year. Proof, vouchers and accounts kept by the tenant are considered conclusive evidence of the expenses. Section 25 to 27. Subtenancies. Subletting is the act of a tenant renting out the property to someone else under the MRCA. This is strictly regulated to prevent middleman profiting. General prohibition. Section 26. Unless there is a written contract specifically allowing it, a tenant cannot sublet, transfer, or give the premises on license to anyone else. Note: unlawful subletting is a major ground for eviction under Section 16. Section 25. Lawful subtenants become tenants. If a tenant's own interest in the property ends, they vacate or their lease is terminated. Any lawful subtenant, someone sublet with landlord consent, automatically becomes the direct tenant of the landlord on the same terms. Section 27. Government allottees. This section deals with specific historical cases where the government requisitioned premises and allotted them to individuals. It ensures these allottees are treated as tenants under the Act. In the Maharashtra Rent Control Act 1999, the concepts of standard rent and permitted increase are designed to prevent exploitation while ensuring the property remains economically viable for the landlord. Standard rent. Standard rent is the maximum legally permissible rent that a landlord can charge a tenant. It is fixed based on specific historical benchmark to prevent arbitrary price hikes. Benchmark dates. For premises let on October 1, 1987, the rent at which they were let on that date. For premises let after October 1, 1987, the rent at which they were first let. Court's power to fix. If there is a dispute or if the rent is excessive, the court can fix the standard rent. The court considers the provisions of the Act and the fairness of the amount. Finality. Once the court fixes the standard rent, it remains the legal ceiling, and charging anything above it without a permitted increase is punishable offense under Section 10. Permitted increase. Section 7, Subclause 8 and Section 11 to 13. Permitted increase is a legal exception that allows the landlord to raise the rent above the fixed standard rent. This ensures the landlord can recover costs related to inflation, improvements, or taxes. Common types of permitted increases. Standard annual hike under Section 11, a landlord is entitled to 4% increase per annum on the rent of the premises. Improvement or alteration 15%. If a landlord carries out structural alteration or improvement with the tenant's written consent, they can increase the rent by 15% per annum of the expenses incurred for such work. Special or heavy repairs. If landlord carries out heavy repair, they can increase the rent by percentage of the repair cost. Tax pass through. If the local authority increases the property tax or other cesses, the landlord can pass this specific increase on to the tenant. Under the Maharashtra Rent Control Act 1999, standard rent is the legal ceiling on the rent. It ensures that while landlords receive a fair return, tenants are protected from the exploitation or exorbitant market driven spikes. The concept of standard rent is not necessarily market rent. It is a statutory figure fixed by law or by code that represents the maximum legally chargeable amount for a specific premises. The freeze date, the Act primarily pegs the standard rent to the amount being charged on October 1, 1987. Public policy, the goal is to provide housing stability. Any agreement to pay more than the standard rent is void and unenforceable. Components of standard rent. The components vary depending on when the property was first rented, fixed by previous law. If the rent was already fixed by the court under the older Act 1947 Act, that amount remains the standard rent. October 1, 1987 benchmark, if not fixed by the rent at which the premises were let on October 1, 1987. Post 1987 tenancies, if the property was first let after 1987, the rent at which it was first let becomes the standard rent. Increase in rent, permitted increases. Standard rent is not frozen forever. The Act allows for specific lawful increases under Section 11 and 12. Annual 4% increase. Landlords can increase the rent by 4% per annum compounded. Improvements. 50% of the landlord makes structural alteration or provides additional amenities. They can increase the rent by 15% of total expense per year. Special repairs 25% for heavy structure repairs. A temporary increase of 25% may be allowed. Tax hikes. If local authorities increases property tax, the landlord can pass this exact increase onto the tenant. Liability to pay standard rent. Tenant's duty. The tenant is legally obligated to pay standard rent and permitted increases as they become due. Section 15. Protection from eviction. A tenant cannot be evicted if they are ready and willing to pay the standard rent. The 90-day rule. If tenant defaults, the landlord must give a 90-day notice. If the tenant pays the arrears plus 15% interest within 90 days of the court summon, the court will generally grant relief against forfeiture and allow them to stay. Section 8. Application for fixing standard rent. If there is a dispute, either landlord or tenant can apply the small court in Pune or Mumbai to fix the standard rent. Grounds for application. Where there is a dispute over the amount, when the premises were lent rent-free or at nominal rent, when there is no evidence of what rent was in 1987. Interim rent. While the case is pending, court will fix an interim standard rent that the tenant must pay into the court or to the landlord to prevent eviction. Court's power to fix standard rent. The court has exclusive power to determine what it just based on evidence, receipts, old agreements, or municipal assessment records. Comparison. If no data exists, the court looks at the rent of similar premises in the same locality. Discretion. The court can reject an application if it feels the tenant is merely trying to delay an eviction suit. Under the Maharashtra Rent Control Act, the landlord duty to maintain property and their right to recover is for repairs are carefully balanced to prevent tenants from being permanently displaced under the guise of renovation. Section 14. Landlord's duty to repair. The Act places a statutory obligation on every landlord to keep the premises in good and reasonable repair. The rule, the duty exists regardless of any local law or custom. It can only be waived if there is a specific written agreement where the tenant takes on the repair responsibility. Tenant's remedy: if the landlord neglects repair after 15-day written notice, the tenant can carry out the work themselves. Rent deduction: the tenant can deduct the cost of such repair from the rent, provided deduction cannot exceed one-fourth of the rent payable by the tenant for that year. Recovery for repairs, section 16, subclause 1H. A landlord can seek an eviction decree if they can prove to the court that the premises are reasonably and bona fide required for carrying out repairs. These repairs cannot be carried out while the tenant is in occupation. That is, the work is so extensive that the premises must be vacated. Section 16, subclause 4, important constraint. The court may order the tenant to vacate only a part of the premises if the repair can be completed without vacating the entire area. Section 17, tenant's right to re-entry. Section 17 acts as a safeguard to ensure the tenant gets their home back once the repair are finished. The election: when the court passes an eviction decree for repairs, it must ask the tenant if they wish to reoccupy the premises after the work is done. If the tenant says yes, the court records this election in the decree. Landlord's notice: 2 months before the repairs are expected to be finished, the landlord must give the tenant notice of completion date. Tenant's acceptance: within 30 days of receiving that notice, the tenant must accept the accommodation, deposit 1 month's rent with the landlord. Restoration: once the tenant complies, the landlord must place the tenant back in possession on the same terms and conditions that existed before the eviction. Penalties for landlord's default, section 17(3) and 4. The law treats fake repair claim harshly. Failure to start or complete: if the landlord fails to start repair within 1 month of getting possession or fails to finish them in a reasonable time, the court can order the landlord to put the tenant back in possession. Criminal liability: a landlord who fails to start repair without a reasonable excuse or refuses to let the tenant back in can be convicted and fined or even imprisoned in extreme cases of defense. Under the Maharashtra Rent Control Act, Section 25 and 26 regulate the practice of subletting. The Act maintains a strict anti-middleman stance, prohibiting tenants from profiting by subletting unless they have explicit written consent from the landlord. Section 26, prohibition on subletting. This section acts as general ban on the transfer of tenancy rights by a tenant. General rule: notwithstanding any other law, it is useful for the tenant to sublet the whole or any part of the premises, give the premises on a lieu and license basis, assign or transfer their interest in the tenancy in any other manner. The exception: this prohibition is subject to any contract to the contrary. If your original lease agreement explicitly allows subletting, only then it is legal. Penalty for breach: unauthorized subletting is a major ground for eviction under subsection 16(1)(e). If proven, the landlord can recover possession of the entire premises. Section 25, subtenants to become tenant. This section provides a safety net for lawful subtenants. It ensures that if the main tenant leaves or is evicted, the person living under them is not automatically thrown out, provided the stay was legal. The trigger: when the interest of main tenant is determined for any reason. The result: any lawful subtenant to whom the premises were sublet shall be deemed to become the direct tenant of the landlord. Terms of tenancy: the new direct tenant will hold the premises on same terms and conditions as they would have held them from the main tenant if the tenancy had continued. What constitutes a lawful subtenant? To claim the protection of section 25, the subtenant must prove their occupancy is legal. The subtenancy is lawful only if written permission it was created with the express without written consent of the landlord. Historical recognition: the subtenancy was created before the commencement of 1999 Act and was recognized as the lawful under the previous 1947 Act. Deemed legality. Certain historical subtenancies were regularized by government notification, though this is increasingly rare in modern disputes. That was all for this video. See you in next video. Till then, like, share, and subscribe. Thank you.